Welcome to the deep dive. If you've ever stared at an outline trying to figure out if two parties actually, sealed a deal, this deep dive is definitely for you. Our mission today is to really master that essential threshold question in contract law. Was an enforceable contract actually formed? We're taking a serious dive into the foundational legal sources covering offer, termination, and acceptance. Before we can even think about breach or remedies, we have to rigorously confirm three things were met. First, mutual assent, that means offer and acceptance. Second, consideration. And third, the absence of any valid defenses.
That's exactly right. And, to begin that really rigorous analysis, we have to start at square one, figuring out the governing law. We'll establish jurisdiction as a common law or the UCC. Then we'll break down how the power of acceptance is created and sometimes pretty brutally terminated. And finally, we navigate the modern complexities of acceptance, especially under the UCC's, let's face it, dreaded battle of the forms.
Okay, let's unpack this then. First critical question. Before we even look at intent, which body of law applies? Because, like you said, if we get this wrong,
everything else is off. The rules are fundamentally different. The common law of contracts, well, that governs contracts, mostly dealing with services, real estate, and employment. Pretty standard stuff. The Uniform Commercial Code, the UCC, that governs contracts strictly for the sale of goods.
Reds.
And remember, goods are defined pretty broadly, all things, even specially made items, which are movable when they're identified to the contract.
Okay, that seems clear enough. But what happens when you have a hybrid contract? A mix. Say you hire a really high-end contractor for a custom install of a, sophisticated security system. The labor is skilled, it's expensive. But the actual components, the cameras and sensors, the goods, they're valuable too.
Right, those common hybrid situations. For those, we apply the predominant factor test. Basically, the law that governs the entire contract, either common law or UCC, is decided by whatever the main point of the deal was. Was it mostly about the goods or mostly about the services?
Oh, okay.
It's an all-or-nothing approach. You apply one set of rules to the whole thing.
Got it. So let's assume common law applies for a minute. An offer creates this power of acceptance in the person receiving it, the offeree. What's the traditional fundamental common law rule about the offeror's ability to just take back that offer, even if they promise to keep it open for a bit?
Well, the general common law rule is pretty stark. The offeror is the master of their offer. They can revoke it any time before it's accepted, full stop. And importantly, that revocation only works, it's only effective when the offeree actually gets notice of it.
Okay.
This is where you really see that tension, freedom of contract versus protecting someone who might be relying on the offer, especially with unilateral offers.
Right. And here's where we see that tension play out in maybe its harshest form. Let's analyze the traditional limits using Pedersen v. Patberg. First, what are the legally dispositive facts?
Okay, Pedersen. He was offered a discount on his mortgage if he paid the principal off early. So Pedersen actually shows up at Patberg's place, cash in hand, ready to make the final payment. But Patberg revokes the offer right there, literally before the money could change hands.
Wow. Okay. And what was the core legal issue here?
The issue was, can an offer for a unilateral contract, one that requires completing an action, not just a promise, be revoked when the offeree is physically there, totally ready to complete the final act, but hasn't quite done it yet?
What fundamental rule did the court apply in that situation?
They applied the very traditional, kind of rigid common law rule. It allowed revocation anytime before full and complete performance. Just being ready wasn't enough.
So what was the court's analysis? How did they justify that?
Their reasoning was pretty formalistic. Since the offer specifically required the act of payment to accept it, the power to revoke had to remain until that exact moment the payment was finished. They basically said Pedersen showing up ready was just preparation, not the performance itself.
And the conclusion?
The offer was effectively revoked. No contract was formed. It feels incredibly harsh, right? But that was the traditional stance. But it's really important, if you're studying this, note the policy shift here. The defense for that harsh rule was all about preserving the offeror's absolute freedom. But the modern view, the one in the restatement, rejects this. Now, if you start performing a unilateral contract, you basically create a temporary option contract. The offeror can't just revoke anymore.
Ah, okay.
The law evolved to protect that reliance interest and, frankly, prevent the kind of absurd result we saw in Pedersen.
That's a really crucial policy point. Now, offers don't always vanish through direct words. Let's talk about indirect revocation. What is an indirect communication of revocation, and what are the three necessary elements that the offeree have to receive for it to actually count?
Right. Indirect revocation acts as a substitute for the offerer saying, I revoke.
Yeah.
It happens if the offeree gets, number one, correct information, number two, from a reliable source, and number three, information about an act the offerer took that's clearly inconsistent with the offer still being open.
Okay.
This protects the offer. They can't just act on some random rumor. It has to be solid information.
Let's analyze Dickinson v. Dodds. This is the classic example of this rule in action. First, what are the legally dispositive facts?
Okay, Dickinson. Dodds offered to sell property to Dickinson and said he'd keep the offer open until Friday. But then, crucially on Thursday, Dickinson found out from a third party, someone else, that Dodds had already sold the property to another person.
And what was the core legal issue?
Does hearing from a reliable third party that the offerer sold the property somewhere else count as an effective binding revocation of the original offer?
What rule did the court apply there?
They applied the rule of indirect revocation. Basically, getting reliable information that the offerer has done something totally inconsistent with the offer, like selling the thing to someone else, terminates the offeree's power to accept. Why? Because the offerer literally can't sell it anymore.
Makes sense. What was the court's analysis then?
Well, the court reasoned that once Dickinson got that reliable, correct information that Dodds had sold the land, he knew Dodds wasn't serious about selling to him anymore. More than that, Dodds was legally incapable of it. That knowledge instantly killed Dickinson's power to accept the offer.
And the conclusion?
The offer was terminated by indirect revocation before Dickinson tried to accept. So his attempted acceptance later on Friday morning, totally useless, no contract.
Okay, shifting gears now completely to the offeree's actions. What's the rule for just a straightforward rejection? And how does that rejection tie into the common law rule for a counteroffer?
A rejection is simple enough. It's legally effective when the offerer receives it, and boom, it immediately kills the power of acceptance. It's over. Now, a counteroffer under common law does two things at once. It acts as a rejection of the original offer, kills that one too, and at the same time, it creates a brand new offer flowing back the other way. This whole strict approach is dictated by the mirror image rule.
The mirror image rule. Okay, let's see how that rule distinguishes between something that kills the deal and just, asking a question. We'll analyze Ardante v. Horan. First, what are the legally dispositive facts?
Right. Ardante gets an offer to buy property. He sends back a letter that says he accepts. However, the letter also includes language asking about including specific furniture, rugs, draperies, that kind of thing in the sale.
Okay. And what was the core legal issue?
Was that letter a valid acceptance under the super strict mirror image rule? Or did adding that bit about the furniture turn the whole thing into a rejection and a counteroffer instead?
What rule did the court apply?
The mirror image rule, plain and simple. Any supposed acceptance that adds or changes any term operates as a rejection and counteroffer, full stop. Now, this has to be distinguished from what they call a mere inquiry, which is basically just asking a question like, would you consider selling the furniture too? That doesn't kill the original offer.
So what was the court's analysis of Ardante's letter?
The court looked closely at the language Ardante used. They found it implied that his acceptance was actually conditional on getting the furniture. It wasn't just a side question. It read more like, I accept the house, provided you throw in the rugs and stuff. And that conditionality, that attempt to add a term, directly violates the mirror image rule.
And the conclusion?
The letter was deemed a counteroffer, not an acceptance. It rejected the original offer and terminated Ardante's power to accept it.
Okay, now for some rules that are just unavoidable. Termination by operation of law.
Yeah.
What's the legal effect if the offerer dies or becomes legally incapacitated before the offer is accepted? And does it even matter if the offerer knows about the death or incapacity?
Death or legal incapacity automatically terminates the offer, just wipes it off the table. By operation of law, the traditional policy reason is super formalistic. A dead person, or someone legally incapable, can't possibly manifest the necessary intent to be bound by a contract. And crucially, this termination happens whether the offeree knows about it or not.
Wow, that seems like it could cause some real problems, especially in business. Let's analyze Swift and Kobe Smigel.
Yeah.
This case tested that rule with a continuing offer right. First, what are the legally dispositive facts?
Yes, Swift. Swift had a continuing guarantee from Smigel. Smigel promised to cover debts that a third party might incur with Swift, kind of like an open offer to guarantee future debts. Later, Smigel was legally declared incompetent, but Swift had absolutely no notice of this fact and kept extending credit to the third party, relying on that guarantee.
Okay. And what was the core legal issue?
Does being legally declared incompetent automatically terminate a continuing guarantee offer if the creditor, the offeree, Swift in this case, has zero notice of the incapacity?
What rule did the court apply here? Did they stick to the harsh traditional rule?
Well, they actually distinguished incapacity from death in this specific commercial context. While death terminates regardless of notice, they argued that for a continuing offer, like this guarantee, that commercial fairness kind of requires that the offeree get notice of the incompetency before their power to accept future extensions of credit is cut off, especially if the offeree, like Swift, acted in good faith.
Interesting. So what was the court's analysis? How did they justify deviating?
In these commercial deals, the court put a higher value on protecting the innocent party's reliance. Swift was relying on that guarantee. They reasoned that if the offeree acts without knowing about the incapacity, the continuing offer should stay effective to prevent an unfair loss. It's sort of balancing that legal formality against business realities.
And the conclusion in Swift.
The continuing guarantee was not automatically terminated by the unnoticed adjudication of incompetency. Smigel's estate was held liable for the credit Swift extended before they received formal notice.
Okay, let's circle back to that potential unfairness we saw way back in Pedersen. You mentioned the modern rule is different. So leaving aside formal option contracts that need separate payment and the UCC special rule for merchants, how does simply starting performance make a unilateral contract offer irrevocable today?
Right, under the modern rule, which is codified in Restatement Section 45, starting the requested performance for a unilateral contract actually creates an implied option contract. This makes the original offer temporarily irrevocable. It basically forces the offerer to give the offeree a reasonable amount of time to finish the performance they already started. It fundamentally protects reliance.
Let's analyze Brackenbury v. Hodgkin. This is a classic case showing performance locking the deal in, right? First, what are the legally dispositive facts?
Exactly, Brackenbury. Hodgkin offered her daughter and son-in-law, the Brackenburys, her farm, the condition. They had to move from Maine all the way to Massachusetts and take care of her for the rest of her life. So they did it. They packed up, moved in, and started caring for her. But then later on, Hodgkin tried to revoke the offer and kick them out.
Okay. And what was the core legal issue?
Did their act of moving to the farm and actually starting the care constitute the beginning of performance needed to make Hodgkin's unilateral offer irrevocable under that modern rule?
What rule did the court apply?
The rule is that beginning the actual requested acts in this case, moving in and starting the lifelong care, locks the offer in place. This is crucially different from just preparing to perform, like maybe getting quotes for moving trucks or looking up directions. That wouldn't be enough.
Got it. What was the court's analysis of the Brackenburys' actions?
The court found the Brackenburys had taken really substantial, life-altering steps that were directly requested by the offer. They moved their entire lives based on this promise. They started the long-term care Hodgkin asked for. This was way beyond mere preparation. It was the actual beginning of the performance.
And the conclusion?
The offer became irrevocable the moment they started performing. Hodgkin couldn't just take the farm back. The Brackenburys were entitled to the property, assuming they continued to fulfill their end of the bargain, caring for her for life.
Okay, now for the big shift, modern commerce. Let's turn to the sale of goods. And here, as you mentioned, the common law's mirror image rule gets, well, completely thrown out. What's the core purpose of UCC Section 2207? Why did we even need it?
Its purpose is all about reflecting how business actually works today. Companies send these standardized purchase orders and acknowledgement forms back and forth all the time. And guess what? They almost never match perfectly. The UCC needed a way for contracts to still be formed despite these clashing forms. So 2207 explicitly gets rid of the mirror image rule for goods contracts. It also gets rid of the old, often unfair, last shot rule, which gave the advantage to whoever sent the very last form before performance started.
Okay, so how does Section 2207, subsection 1, allow a contract to form even with different terms?
Subsection 1 basically says that a definite and timely expression of acceptance, like sending back an acknowledgement form quickly, can form a contract even if it states terms that are additional to or different from those in the original offer.
So the writings form the deal.
Exactly. The writings form the contract first, and then you figure out the specific terms later under subsection 2.
But you mentioned there's a crucial exception, a potential deal breaker in 22071. When is a contract not formed on the writings, even if acceptance seems definite?
Right. A contract is not formed under one if the acceptance is expressly made conditional on assent to the additional or different terms.
Hmm.
And courts interpret this very strictly. The language has to be crystal clear that the offeree is basically saying, I'm not willing to do this deal unless you explicitly agree to my new terms. It's a high bar.
Let's analyze Dorton v. Collins and Aikman Corp. This case really helped define that high bar, didn't it? First, what are the legally dispositive facts?
Yes, Dorton is key. Dorton sent purchase orders for carpet. Collins and Aikman, the seller, sent back acknowledgement forms. These forms contained an arbitration clause on the back. And the forms used some pretty standard boilerplate language, like subject to all the terms and conditions printed on the form, including the arbitration clause.
Okay, and what was the core legal issue?
Did that boilerplate subject to language rise to the level of making the acceptance expressly conditional on assent to the arbitration term? Did it stop the contract from forming under 2207?
What rule did the court apply to decide that?
The court applied the rule that to be expressly conditional, the language has to really clearly communicate that the offeree is unwilling to proceed unless the offerer specifically agrees to the new terms. Just saying subject to terms on back or similar boilerplate usually isn't enough. It doesn't clearly signal that unwillingness to proceed otherwise.
So what was the court's analysis of the subject to language in this case?
They found the subject to language too ambiguous, too standard. It didn't meet that very high threshold required by the UCC to prevent contract formation. They reasoned that if every form that just said subject to killed the deal, then Section 2207 would hardly ever apply, undermining its whole purpose. So a contract was likely formed on the writings despite the different term.
And the conclusion?
The case was sent back down, remanded, to the lower court. First, to definitively confirm that a contract was formed under 22071. And then, assuming it was, the court would need to move to Section 22072 to figure out if that arbitration clause actually became part of the contract as an additional term. Okay, so for you, the listener, needing that actionable tool to untangle all this modern UCC complexity, here is the absolutely essential 4-step diagnostic checklist. You need this for issue spotting any UCC Battle of the Forms problem on an exam. Follow these steps exactly. Step 1, threshold question. Is this contract primarily for the sale of goods? If the answer is no, it's services, land, etc. Stop right there. Forget the UCC. Apply the common law mirror image rule we talked about earlier. If yes, it's goods, then proceed to step 2. Step 2, contract on the writings. Check Section 2207. Was the second form, the acceptance, a definite and seasonable expression acceptance? Usually yes. If so, now look for the deal breaker. Is that acceptance expressly conditional on assent to the new or different terms? If the answer is no, it's not expressly conditional, great. The contract is formed based on the writings. Move to step 3 to figure out the terms. If the answer is yes, it is expressly conditional, then that acceptance acts like a counteroffer. No contract is formed on the writings. Skip step 3 and go directly to step 4. Step 3, terms of the written contract. Analyze Section 2-207Q.
Okay, so you decided in step 2 that a contract was formed on the writings. Now, what are its terms? Additional terms, terms in the acceptance that weren't in the offer, are treated as proposals. Between merchants, they automatically become part of the contract unless they materially alter the deal, the offer limited acceptance, or objection was already given. Different or conflicting terms, like one form having arbitration, the other not, most courts apply the knockout rule. The conflicting terms cancel each other out, they're knocked out and replaced by UCC gap filler provisions. Step 4. Contract by conduct. Check Section 22073. You get here if the writings failed to form a contract back in Step 2 because the acceptance was expressly conditional. Now ask, did the parties act like they had a contract anyway? Did the seller ship the goods?
Did the buyer accept and pay for them? If yes, their conduct forms a contract. What are the terms of this contract formed by conduct? The terms are only those on which the original writings actually agreed. Everything else, all the additional or conflicting terms from both forms gets knocked out and replaced by UCC gap fillers.
Wow. That was an incredibly thorough deep dive into contract formation. We really covered the ground, didn't we? From the harshness of the old traditional rule needing full performance in Pedersen, to the modern protection of reliance when performance begins in Brackenbury, and then finally wrestling with that massive shift in complexity the UCC brought with Dorton and the Battle of the Forms. We've covered that whole spectrum, so what does this mean for you, the listener? It really means knowing exactly where to pivot your analysis. If you see a contract for services or land, you've got to stick rigidly to that common law mirror image rule. No wiggle room. But if it involves the sale of goods, that 4-step UCC Battle of Forms checklist we just went through, that is your absolutely essential weapon. It ensures you don't miss how, or even if, a contract was actually formed.
And, this raises a really interesting kind of forward-looking policy question, building right off our discussion about death and legal capacity terminating offers. We noted the traditional rationale, a dead person can't manifest intent. But think about the rise of smart contracts, things run by decentralized autonomous organizations, DAOs. These entities, these complex codes, they can effectively cease to exist or function correctly, often without any immediate human notice. So, how should contract law evolve to determine intent and capacity when one of the contracting parties is essentially an algorithm or a block of code that might silently disappear or malfunction? It's a really compelling future issue that directly challenges those core concepts of intent and manifestation we reviewed today,